There have been updates in the Jussie Smollett file, and what we are seeing right now is a fleshing out of Jussie Smollett's defense and an illustration of the principle that in law, the best defense
is a good offense.
Viva Frei, Montreal litigator turned YouTuber, and it is time for an update in the Jussie Smollett file. Now, there has been a lot of paper being pushed back and forth, a lot of procedural stuff going on in the Jussie Smollett file, some of which is more or less interesting. One of the procedural battles that is currently ongoing is Jussie Smollett filed a subpoena duces tecum on the City of Chicago Office of Inspector General. A subpoena duces tecum, for those of you who don't know, is an order to appear and bring with you certain documents. And for those of you who are fortunate enough to have never experienced a subpoena literally is an order of the court. It is issued by an attorney, but it is an order of the court. And so a validly served subpoena duces tecum creates obligations on the recipient to appear at court on the date specified in the subpoena and to bring with them the documentation required in the subpoena. And for those of you who are fortunate enough to have never had any experiences with a subpoena, if you receive one, it doesn't matter if you agree with it or disagree with it. It doesn't matter if you're going to be out of town. If you have been validly served with the subpoena, you have to comply with it. You have to comply with it under penalty of law, or you have to go to court and have a judge say that you no longer need to comply with that subpoena. And that in the industry is what we call quashing a subpoena, and it requires a motion to quash a subpoena. So Jussie Smollett served a subpoena duces tecum on the City of Chicago Office of Inspector General requesting a slew of documents. The City of Chicago filed a motion to quash that subpoena. We're not going to get into that motion for the purposes of this vlog, except to say that Jussie Smollett filed a response to the city's motion to quash the subpoena of the subpoena they issued on the City of Chicago Office of Inspector General. In Smollett's response to the city's motion to quash that subpoena, Smollett describes the Office of Inspector General as follows. The OIG is an independent, nonpartisan watchdog for taxpayers of the city. The OIG exists to investigate misconduct, inefficiency, and waste within the city government. By city ordinance, the OIG shall keep its investigative files or reports confidential and shall only divulge them to the United States Attorney, the Illinois Attorney General, or the State's Attorney of Cook County. The ordinance does not authorize the OIG to share its investigative files and reports with the city. Given what Smollett is describing as the OIG's objectives, we don't need to have a creative imagination to know where Jussie Smollett is going with this request. Jussie Smollett is presumably going to ask for a slew of documentation from the OIG in order to show the City of Chicago's waste in its investigations, either specifically with Jussie Smollett or in general. And we can see where Jussie Smollett is going to go with this in respect of his defense to the City of Chicago's claim against him to recover the costs they incurred in the context of the investigation. Now, I am not going over the fact pattern in the Jussie Smollett saga in this vlog. If you want to catch up on everything that's been going on in that file, check out the Jussie Smollett playlist right here. All that to say is the City of Chicago is suing Jussie Smollett for recovery of the costs incurred in the investigation under the CRO, the Cost Recovery Ordinance, and the FSO, the False Statement Ordinance. And so we can clearly surmise here that Jussie Smollett is requesting a slew of documents from the OIG in order to make evidence of some sort of city waste in the context of the investigations, so as to minimize the amount the city might be claiming from Jussie Smollett and the amount that Jussie Smollett might owe to the city. Jussie Smollett, through counsel, has issued and served this subpoena duces tecum on the OIG, and now the City of Chicago has filed a motion to quash that subpoena to kill any legal obligations that that subpoena would create. But enough with the subpoena, let's move on to the juicy stuff. I didn't even do that on purpose, I swear to you. Not only has Jussie Smollett served this subpoena duces tecum on the OIG, but they have made a request for documentation from the city, and the request is exhaustive. And for anybody who has ever wondered why the litigation process, and more specifically the discovery process, is so darn costly, time-consuming, and a question of pushing paper, this request for documentation is going to show you why exactly. Defendant counterclaim plaintiff Jussie Smollett's first set of document requests to the City of Chicago. And let's just unmix that word salad. Defendant counterclaim plaintiff Smollett. There is a saying that the only way lawyers maintain a monopoly over the practice of law is by ensuring that nobody understands the terminology. As you know, Jussie Smollett is the defendant to the City of Chicago's lawsuit. He is also a counter plaintiff for malicious prosecution by the city. And in the context of this lawsuit, that makes him both the defendant and the counterclaim plaintiff. This is Jussie Smollett's first set of document requests to the City of Chicago because there could and very well be more. Defendant Jussie Smollett, pursuant to Rule 34 of the Federal Rules of Civil Procedure, hereby requests that the City of Chicago deliver to undersigned counsel within 30 days after service hereof the following information for inspection and copying. I'm going to skip over the 2 pages of definitions. Yes, there are actually 2 pages of definitions and 3 pages of instructions as to how to proceed with this request before we get into the actual documents requested. Request for production. 1. Any and all communications between, by, or among city employees relating to or referring to Mr. Smollett or the investigation of the incident. 2. Any and all documents and communications including emails, text messages evidencing or referring to a racist or homophobic sentiment from all work-issued and personal cellular email accounts between, by, or among persons involved with the investigation of the incident, including. I'm actually not going to show the names because I don't want to get into any trouble or accusations on YouTube, but there are 45 people listed under that request. 3. Any and all documents and communications discussing or related to potential or actual charges or a criminal complaint against Mr. Smollett. 4. Any and all documents and communications, including transcripts, recordings, audio or video, or notes relating to any interview, questioning, or interrogation of any person in relation to the incident. 5. Any and all documents and communications relating to or regarding Abimbola Osundairo or Olabinjo Osundairo, including any potential criminal complaint the city considered filing against them. And we can go on forever because this request literally goes on for another 2 pages and consists of 19 items. Bottom line, Jussie Smollett is requesting for anything and everything directly or indirectly related to the investigation against him or the Osundairo brothers in the context of this entire saga. But wait, there's more. Any and all documents regarding disciplinary actions or complaints of misconduct concerning any person involved in the city's investigation of the incident throughout the course of their employment with the city. And you don't need to be Alan Dershowitz to know exactly where Jussie Smollett is going with this. He's going full O.J. Simpson defense, which is going to be a full all-out attack on the City of Chicago Police Department. What is the city's response to this massive request for documentation from Jussie Smollett? They have petitioned the court for entry of a confidentiality order. The title of the motion itself is relatively self-explanatory, but let's read through it to see the details. Plaintiff City of Chicago and the counterclaim defendants, collectively the city defendants, respectfully move this court to enter the city defendants' confidentiality order, pursuant to the Federal Rule of Civil Procedure 26C. In support of its motion, the city defendants state as follows. And here you have the same sort of legalese going on. You have the City of Chicago, which is both the plaintiff and the counter-defendant to Jussie Smollett's counterclaim, and the other counter-defendants who, while not plaintiffs to the City of Chicago's lawsuit, are nonetheless brought into this by way of Jussie Smollett's counterclaim against the City of Chicago and the other defendants. More legalese, but I digress. The city defendants and Jussie Smollett largely agree on the terms of the confidentiality order, and those terms generally track this district's model confidentiality order. Despite conferring several times by phone and email, however, the parties have not been able to agree to designate as confidential 2 categories of information that Smollett is seeking in discovery. 1. Information contained in certain police file materials that is otherwise prohibited from public disclosure by statute, including specifically information in certain Chicago police misconduct complaint files, such as investigation files commonly referred to as complaint registers. And 2. Employment information that is of a sensitive or non-public nature, including specifically disciplinary records. Smollett has requested the following documents which implicate those 2 categories of information. Quote, any and all documents regarding disciplinary actions or complaints of misconduct concerning any person involved in the city's investigation of the incident throughout the course of their employment with the city. So the bottom line here is that the City of Chicago and Smollett's attorneys have agreed on a confidentiality order that covers the vast majority of the documents requested by Jussie Smollett, with the caveat of the request for documents that we just covered. But even then, it's not a question of not communicating the documents. It's a question of whether or not they will be governed by the confidentiality order. I suspect a lot of you might be asking yourselves, why do the parties get to determine what remains confidential in terms of documentation communicated between the parties? Court proceedings are public by their very nature, and it should not be up to the parties to determine what remains confidential in the context of those court proceedings. The quick answer to that question is it's not the parties themselves who are agreeing as to what remains confidential. They are submitting this confidentiality order to the court ratifies it, and it therefore becomes an order of the court. This may very well not quell any of your concerns because now it's not the parties who are deciding, but it's the court sort of playing along with the parties to keep documents confidential that ought to be disclosed to the public. And that is a debate for another day. But what is the City of Chicago's justification to keep this set of documents confidential, and why would Jussie Smollett object? Paragraph 4, Rule 26C of the Federal Rules of Civil Procedure permits the courts to, quote, for good cause, issue an order to protect a party or persons from annoyance, embarrassment, oppression, or undue burden or expense. In determining whether there is good cause for a protective order, the court must balance the harm to the party seeking the protective order against the importance of public disclosure. Paragraph 5. Here there is good cause to enter a protective order as to the 2 contested provisions. The city does not seek to prevent production of any relevant documents in either category. Rather, the city merely seeks to designate these documents as confidential to avoid the undue burden of redacting extremely voluminous materials before producing them to defendant, while ensuring that all information protected from disclosure by statute is properly redacted prior to any public dissemination of the information. Paragraph 6. As to the police misconduct complaint files, the city recognizes that these files are no longer afforded blanket protection under Illinois law. There is, however, information contained within those files that remains protected by statute, and the Calvin Court recognized that these files may thus require screening, including in-camera review, prior to any public dissemination to ensure that the files are properly redacted in compliance with the specific specific statutory protections implicated. Paragraph 8. While court proceedings generally are open to public scrutiny, not all materials produced in discovery but unfiled in court proceedings may be freely available or disseminated to the public. To the contrary, courts have consistently provided confidential protection for the kind of unfiled, sensitive documents at issue here. In Seattle Times Company versus Reinhardt, the Supreme Court held that the public's right of access is limited to traditionally public available sources of information and, quote, restraints placed on discovered but not yet admitted information are not a restriction on a traditionally public source of information. The court recognized that Federal Rules of Civil Procedure 26C allows for protection from annoyance and embarrassment, and while Rule 26C does not contain a specific reference to privacy, privacy is, quote, implicit in the broad purpose and language of the rule. Paragraph 11. Smollett has requested the complaint files for, quote, any person involved in the city's investigation of the incident throughout the course of their employment with the city. Smollett has identified 45 police officers that it contends were involved in the city's investigation of Smollett's attack. Determining which information is protected by IFOIA or by provisions of other statutes existing in voluminous CR files can only be determined upon close investigation in an often burdensome, tedious, and time-consuming case-by-case, page-by-page, paragraph-by-paragraph review. Just to avoid any uncertainty, the IFOIA is the Illinois Freedom of Information Act. And just skipping to the end because I think we get the idea, paragraph 17 reads as follows. Due to the private nature of the information contained in personnel and disciplinary files and the significant burden of redacting information protected from discovery by statute, there is good cause for deeming this category of documents confidential and subject to protection. Including these documents in the confidentiality order will minimize discovery disputes by allowing the city to produce full, unredacted responses to Smollett's relevant document requests. And because there are no favors in litigation, Jussie Smollett's attorneys are opposing this request for a confidentiality order. Defendant counterclaim plaintiff Jussie Smollett, by and through his attorneys, hereby respectfully submits this brief response in opposition to the motion for entry of a confidentiality order. Their first argument is quite logical, and I had the same reflex myself. First, to the extent that the city defendant's concern involves information in CR files that is prohibited from disclosure by statute, such information is already protected under Category A of both the agreed protective order and the proposed confidentiality order. Therefore, Category G of the proposed confidentiality order regarding any information contained within CR files that are otherwise prohibited from public disclosure by statute is superfluous at best. Now, this may be a little confusing, so just to clarify it a little bit, there is a draft confidentiality order that has been circulating among the parties. Under the provisions of that draft confidentiality order, it is already provided that that which is protected by statute shall remain confidential. So the City of Chicago's argument that they need the confidentiality order to protect that which is already protected by statute, which is already covered in the draft confidentiality order, is superfluous. So they don't need double protection for those documents because any documents that are already protected by statute are already going to be covered by the confidentiality order as drafted and agreed to between the parties. That is Jussie Smollett's first argument in opposition to the motion to enter a confidentiality order. What is the second argument? Second, the city defendant's contention that the disciplinary records and CR files are protected from public disclosure is incorrect as a matter of law. The city defendant's admission that CR files, quote, are no longer afforded blanket protection under Illinois law is an understatement. The Illinois Personnel Records Review Act clearly shows that disciplinary records are not protected and are public records under the Freedom of Information Act. In sum, as a matter of law, both the CR files and disciplinary records are public records, and so it is not necessary or warranted to include them in categories of confidential information in the confidentiality order. Smollett's third argument in opposition to the motion to enter a confidentiality order is whatever, I'll read it. Third, the city defendant's remaining argument in favor of their proposed confidentiality order regarding the purported, quote, undue burden of redacting extremely voluminous material before producing them is either premature or a red herring. The third argument is thin, the first argument is solid, and the second argument is revealing. Why would Jussie Smollett oppose a confidentiality order that would cover disciplinary records and complaint registers? The answer is simple. He wants these things to go public. He wants to go full O.J. Simpson defense on the entire City of Chicago Police Department, revealing and releasing all of their disciplinary records, complaint registers, etc., to show how badly they all behave in the context of their employment. He wants to make this all go public so that people lose confidence in the entire police department itself. He wants to go after each and every person who had a hand in this investigation to reveal any disciplinary measures that were issued against them, any sanctions, any punishments, etc. This is the perfect illustration of the maxim that sometimes the best defense is a good offense. If you can't prove your own innocence, prove everyone else's guilt. We will see where this goes, but bear in mind what is going on here. This is a procedural fight over the conditions of communication of documents. We haven't even had discoveries yet. We haven't even had the debate over the admissibility of documentation that has yet to be communicated between the parties. When I say that litigation is a long, tedious, tedious, costly, and soul-crushing process, you are now beginning to fully appreciate the extent to which it actually is. This file has barely gotten started and we are already bogged down in procedural muck and mire. Alright, that is it. To be continued, but if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. If you want to buy some merch, I am not wearing merch today, but the merch links are in the pinned comment below with a PayPal option for anybody who feels more comfortable with that. If you haven't seen my first Jussie Smollett vlog, I'm going to link it right here. Give it a watch, and now you know your vlog. Peace out. Booyah!